What is affirmative action?
Affirmative action refers to policies that take factors including race, religion, sex, or national origin into consideration in order to benefit an underrepresented group in areas of employment, education, and business.
How does that affect us?
It affects our ability to get into higher education or be employed after that.
Well, what's its purpose?
The purpose of affirmative action is to benefit subsets of society that are believed to be at a disadvantage. These groups can be categorized by race, religion, gender, sexual orientation, whatever group is perceived to be at a disadvantage.
So, how is affirmative action any different than reverse racism?
It really depends on who you ask.
Some people would say that affirmative action has nothing to do with racism. It's simply just leveling the playing field.
Some people would say affirmative action is no different than reverse racism. The policy puts the majority at a disadvantage, just as regular racism would put it in the minority.
It's still a hot topic to debate today.
What's the relation between affirmative action and the 14th Amendment's Equal Protection Clause?
It states that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, property, without due process by the law, nor deny any person within its jurisdiction equal protection of the laws.
So, how does that have anything to do with affirmative action?
The Equal Protection Clause states that every state law must treat all citizens equally, unless rights are removed from them by a conviction in court. This could spark a debate on whether or not public colleges or universities are violating the Constitution or their affirmative action policies. Private colleges and universities would be exempt from such laws, but state schools would have to follow what the Constitution mandates.
What do any Supreme Court cases say about the constitutionality of affirmative action?
Okay, so one of the big ones was the reasons of University of California versus Bake in 1978. It upheld affirmative action, allowing race to be one of the many factors college administration policies. However, the court ruled that specific quotas, such as 16 out of 100 seats set aside for minority students at the University of California, Davis School of Medicine, were not allowed.
Any more?
Another one was Grutter versus Bollinger in 2003.
A Michigan law school denied admission to Barbara Grutter, a female Michigan resident with a 3.8 GPA and a 161 LSAT score, comparable to a 32 on the ACT. Grutter claimed that she was discriminated against on the basis of race that violated the 14th Amendment. She claimed she was rejected because the law school uses race as a predominant factor.
The Supreme Court ruled that the University of Michigan Law had a compelling interest in promoting diversity. The court held that a race-aware admissions process that may favor underrepresented minority groups, but also took into account many other factors evaluated on an individual basis for every applicant, and it was not the same as the quota system that would have been unconstitutional under the Regents of the University versus Bake.
It seems like the Supreme Court thinks that affirmative action is constitutional.
It seems that way.
Yes, another case on affirmative action is still in the Supreme Court, again over Michigan state policies.
What's the difference between affirmative action and the 14th Amendment? Equal Protection Clause.
Race, religion, sex, or national origin into consider religion, sex, or national origin. Since the University of California v. Bake, Another one was Grutter v. Bollinger.